Over the last few lessons, we've been talking about the various different approaches within legal positivism as part of a jurisprudential theory of law. We talked about classical legal positivism, talking about the likes of people like John Austin and the interpretations of legal positivism from that perspective. We then talked about more modern theories of legal positivism, introducing the writings and the philosophy of H.L.A. Hart, a legal positivist who was writing post the Second World War in relation to legal positivism. This lesson is going to dive into the details of positivism as presented by the likes of people like Hart. We're essentially going to be talking about some of the key components of Hart's legal positivism because these are going to crop up in a bit more detail in the next lesson when we look at the responses to the likes of people like H.L.A. Hart by writers such as Ronald Dworkin, who would respond to these and critique legal positivism from his perspective. So, essentially, the legal positivism that is conceptualized by Hart is a conception of law as based on basic rules, okay? So remember, we're beginning to think about some of the ontological questions of law. We're talking about the approaches to law and the questions of what something is or is not in relation to law, i.e. whether or not something is or is not a law, and why and on what basis this is determined. For a natural law scholar, this could be reference to the moral law, the morality that is ascribed either, namely through Christian theology, if we're thinking about classical natural law, or even theories of natural rights, if we're thinking about the people such as Finis and Fuller. When we talk about legal positivists, they detach morality from the conception of law that is ascribed as to essentially suggest that you can have a law which does not adhere to basic moral principles, but it would still be law. And Hart is no different in his conception of legal positivism, and he develops a conception of law that is based on a series of rules. He will divide these rules, in inverted commas, into two major categories. Hart describes on the one hand the existence of primary rules, and then on the other hand the existence of secondary rules. All very simple at the moment. Now, within Hart's conception of legal positivism, primary rules are the rules that instruct people in society, instruct us as members of society about what we may and may not be able to do. So, as essentially a primary rule instructs one to understand how best to act in a particular circumstance. In a particular circumstance, what are the rules in terms of how we can and cannot act? These are the regulations of law which are for the proper running of society, essentially. So things like road traffic laws, all of which would fall into the category of the primary rules. They instruct you on how you can and cannot act when you are on the road, for example. The speed limit that you go, whether or not you should stop at a red light, whether or not you should give way or you should indicate when you get off a roundabout, etc., 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 all of which are road traffic laws. Whether or not you can drink and drive also is a primary rule, i.e., you can't, is the answer to that question. And it is telling us and instructing us about what we can and cannot do. Without these primary rules, these rules of regulation that are established by Hart, it is argued that society cannot run in a proper and functioning way. So without road traffic law, for example, we wouldn't have a very properly functioning society in relation to the way in which we regulate our roads. We would have essentially motor anarchy, if you will. There are also rules about paying taxes on time. These also include and are part of the category of primary rules that is established by Hart. So, essentially, what we describe as a primary rule is what Hart would argue is a rule that if we didn't follow, the structure of society would collapse. So, for example, if no one paid their taxes, then there would be no way to pay for the roads that we have road traffic laws for, or hospitals, or the police, or fire, or education, and essentially society would collapse. So these are considered to be primary rules. If we didn't have road traffic laws, then everybody would go through red lights, they could go at whatever speed they like, they could drink and drive, they could drive under the influence. you'd have lots of crashes, you would have anarchy on the roads, as I've mentioned, and you would end up with a collapse of the basic structure of society. All of which suggests, therefore, that primary rules are required for the proper running and the proper functioning of our society. On the other hand, secondary rules are a little bit more complicated, and they are actually further subdivided into other categories. Ultimately, these are divided into rules of change, rules of adjudication, and rules of recognition. These are the major categories, or subcategories, should I say, of the secondary rules within society. A rule of change is what Hart uses to argue that essentially any society has to have in order for something to be called law. So what Hart argues when it comes to rules of change is that the existence of something called law must have a way to change the law. So the idea of law, according to Hart, is not something that is static. Law is not something that you create and then you could never, ever, ever change. The purpose of law in any society is for its ability to change in some kind of way. And so the primary rules will need secondary rules for you to tell them how, for you to know, shall I say, for them to tell you how to change them, essentially. So one of the examples of how we can apply this in our day-to-day lives in terms of the English legal system is the fact that Parliament can pass statute, and those statutes can change the pre-existing legal principles that exists. Let's say there is some new thing that takes place, a new traffic accident that takes place that requires a further adaptation and change to road traffic law to essentially to regulate and to make those roads safer. Or Parliament could pass a law or pass a statute or pass an amendment to a particular piece of statute to essentially change the pre-existing legal principles that existed and make changes to the primary rules. The second principle is the rule of adjudication, and what the rule of adjudication suggests is that for a legal system to be considered a legal system according to a Hart positivist perspective, there must be some way for disputes about primary rules to be settled. So it is not enough to just have primary rules that exist and for us to all just follow primary rules, because there will always be situations where the primary rules give rise to disputes, where one side of an argument decides that they are in the right and the other side actually argue that they're in the right. And the primary rule may be quite vague on how to actually apply that principle to the day-to-day facts of that particular case. And so with the existence of a legal judicial system, you satisfy the rules of adjudication, because what a judicial system essentially allows us to do is to adjudicate over the primary rules. If there is a case where an individual has, if we continue with the case of road traffic law, an individual has been accused of driving under the influence. Okay, now this is a criminal offence, and so it is up to the rules of adjudication, i.e. the judicial system, more specifically the criminal justice system, to essentially adjudicate on the settlement of that particular primary rule, on whether or not that individual is in contravention of the primary rule that has been established. Finally, then, you have what are known as rules of recognition. These are arguably the most problematic of the three secondary rules that we established. There is only essentially one rule of recognition, and what Hart suggests is that the rule of recognition is derived from internal knowledge rather than from our external empirical understanding of the world. So what we suggest here is that they are a priori in terms of the ability for us to recognize rules of recognition. And what a rule of recognition is, and what it means, is that people who are internal to the existing legal system must recognize a rule, a primary rule, as law. So if you are part of an internal legal system, a part of an internal society, you must be able to satisfy the rule of recognition. You must be able to recognize that a primary rule is law. And so as a result of which it is a piece of legislation, or it is a principle or a rule that one must be able to follow. Finally then, let's just talk about the distinctions that can exist between Austin's positivism and Hart's positivism. They are very different in a number of different ways. They are both positivist in nature because they both share some of the most fundamental elements of legal positivism. But one of the key distinctions that it can be made between Hart and Austin is that Hart does not rely on the concept of a sovereign to essentially legitimize the basic principles of law. This is very useful because it allows for us to understand and to have a conception of legal positivism, which also allows for us to have a conception of international law as being part of that broader conversation in jurisprudence. One of the things that makes people quite uncomfortable about Austinian positivism is the fact that what is seemingly a legal system in and of itself, public international law, does not seem to have the same kind of recognition of law or as law that domestic systems will have. Now, that's still a position that a lot of people still hold, specifically domestic lawyers in academic circles. But for the most part, you would recognize that even though international law is different in a number of ways to domestic legal systems, it is still nevertheless considered law. So how does Austin get around this? Well, it's very difficult for him to do so. He simply just denies the existence of international law, or at least he accepts maybe the existence of international law, the basic principles, but he does not recognize that those things are law. Hart, on the other hand, can. And so, as a basis of not relying on sovereignty as being the fundamental cornerstone for the legitimacy of law, what Hart is able to do is allow for the existence of international law. It does not broadly deal with the complexities of sovereignty and questions of as to where sovereignty is to be located. This is another conception of Austinian positivism that's quite difficult to derive. It's all well and good saying that law is derived and legitimized on the basis of sovereignty, but where does sovereignty come from, and whereabouts can we locate sovereignty in a specific legal system? That's a little bit more complicated. Again, something that is not relied upon by the works and writings of HLA Hart.